Hi, everybody. It's 2 o'clock. I'm going to give it one more minute and then we will get started. Thank you, everyone, for joining us. Okay, let's go ahead and get started. My name is Vicki Nielsen. I'm with the Catholic Legal Immigration Network, and we're so excited today to be presenting our webinar on understanding and screening for statelessness. We're going to cover several topics. First, explaining what statelessness even is, and then describing, why it matters, what happens to people when they're stateless. And then we're going to take a deep dive into screening for stateless people, because it's actually pretty complicated to figure out if someone even is stateless. And then we're going to touch briefly on possible forms of relief. If people have substantive questions, please type them in the Q&A box, and we will do our best to get to some Q&A by the end of the webinar. So as I said, my name is Victoria Nielsen. I'm the managing attorney of CLINIC's Defending Vulnerable Populations program, and I'm joined today by two amazing speakers. Do you want to introduce yourself, Karina?
Hi, my name is Karina Ambartsumian-Clow, and I'm a founding member and currently serving as the executive director for United Stateless.
Yes.
Hi, my name is Jessica George, and I'm an attorney based in Baltimore, Maryland. I am an advocate and ally with United Stateless.
And Karina, can you tell us a little bit about United Stateless?
Yeah, we are a stateless-led and ally-supported national organization with a mission to build a community among those affected by statelessness and to advocate for a human right to a nationality.
And as I said, I'm with the Catholic Legal Immigration Network, Inc. We are a training and support hub for over 400 nonprofits around the United States that work with vulnerable immigrants. And we are really excited to be part of a partnership with United Stateless. Thanks to funding and leadership from UNHCR, USL and CLINIC entered into a partnership for this year to increase awareness of statelessness, to mentor attorneys, provide resources for practitioners. And, overall, as we're going to hear today, statelessness is a problem that is really invisible in many ways in the United States, and we want to make people more aware of the issue and to start to think about what possible solutions may be. And part of what we really want to do with this partnership is to establish a community of practitioners, because many of the issues that one sees when working on a stateless case seems like a novel issue, like there's just not a lot of guidance out there. So one thing that we're hoping to do is allow practitioners to share knowledge with one another, to share what works and what doesn't work. So we've created a listserv for that purpose, and we already have over 100 practitioners on that listserv. And if you're interested in joining, just shoot me, Vicki Nielsen, an email at the email address that you see on the screen there, which I can also type in the chat. And with that, I'm going to turn it over to Karina.
Next slide, please. So I'm going to start with kind of very beginning, maybe background information. And I'm sure some of this is probably repetitive for some of you, or maybe this is reminding you of what you once learned in law school or elsewhere. Next slide, please. I would like to start with, with a story. Well, first, let's start with how citizenship is granted. Individuals granted access to their basic human rights because of their recognition or link by a state, which is formerly known as nationality or citizenship. The link is traditionally established by a birth registration, which formally recognizes that person to be tied and linked to that state. And you're either given that birth acknowledgement at birth through jus soli, which is soil, or jus sanguinis, which is blood. And of course, in some cases, people can also gain citizenship or nationality through the naturalization process. And citizenship, in turn, grants that individual access to resources provided by that state, oftentimes for the entirety of that person's life: education, healthcare, mobility, housing, civil engagement, consular protection, political rights, social security, labor rights, etc. Hannah Arendt, a amazing scholar and also stateless herself at one point, coined the phrase that citizenship is the right to have rights. And of course, every country has their own interpretation of nationality laws. Next slide, please. So this is the story part I wanted to get into. You know, at the end of World War II, world thinkers and policy people got together and started talking about like what to address what just happened. There are millions of displaced people. The most atrocious crime in recorded history has occurred and recorded. The question was posted by philanthropists and officials, well, what do we do to make sure nothing like this happens again? And this is the time that the United Nations came together and formed the United Nations High Commissioner for Refugees, or UNHCR, which with their 3 mandates to protect refugees, stateless people, and the internally displaced. Treaties were drawn, countries were strongly urged to adopt these measures to protect the people that are within their borders. And one of the outcomes was, and shout out to Eleanor Roosevelt for her influence, was the Universal Declaration of Human Rights, which is a rudimentary human rights list that every human being, just by living on this planet, deserves. In Article 15, states that everyone has a right to a nationality and no one shall be arbitrarily deprived of his nationality nor denied the right to a nationality. And I just want to point out that I'm going to use the words nationality and citizenship interchangeably, but there are some slight differences that I feel like we don't have time to go into in this slide. Next slide, please. So through those meetings, and an outcome of these gatherings were these 2 conventions. And I would even dare to say lesser known because we are also familiar with the Refugee Convention. In fact, the 1951 Refugee Convention at one point had a stateless protocol, although the adoption was postponed, and attempts to address it during the Refugee Convention were unsuccessful. So a couple of years later, the 1954 convention was held although fewer countries ratified it, and this convention aims to address statelessness by establishing the definition, ensures that stateless people deserve rights through inclusion, protection, and participation by a state, and every stateless person should be given an opportunity to naturalize. Years later, the 1961 convention was introduced, the reduction of statelessness, which then aims to prevent statelessness by addressing statelessness derived at birth, and also put safeguards to address statelessness when state succeeds. It also goes into other issues, but the child aspect of the 1961 convention is a pretty big deal, and we'll go into that later. Next slide, please. So the official definition of a stateless person derived from that convention, the 1954 convention, is a person who is not considered as a national by any state under the operation of its law. We are often called citizens of nowhere. It is also incredibly important to understand the definition of this word and to use it appropriately. You know, I've personally come across moments when statelessness was used to apply to describe the experience of those that have citizenship, and for instance, are living undocumented in the United States, and or our citizens are racially profiled. You know, when you use this word to describe a citizen, you take that one word away that stateless people have to describe their situation. Statelessness is not something that has happened, it continues to happen today. The experience of stateless people intersects with all social justice issues. You are unheard by the law and you're affected by lack of policy. Next slide, please. There are 15 million stateless people worldwide. An estimate, of course, this number is an underestimate as countries are unwilling to sometimes address this issue within their borders. Next, please. A child is born stateless every 10 minutes. Next, please. And it's the most acute and invisible human rights violation. It is oftentimes a prelude to atrocity crimes. Before the Armenian genocide, the Holocaust, Cambodian genocide, and the most recent Rohingya, series of laws and policies were passed excluding and denationalizing citizens of certain ethnic, sometimes even sexual identity, religious and racial background. Statelessness is not in control of the person that has happened to. It's a systematic issue to dehumanization. Next slide, please. Stateless is almost always caused by some nations' laws or practice rooted in racial, gender, ethnicity, or religious-based discrimination. I also think we will continue to witness more nationality stripping tied with the rise of climate change and the socioeconomic vulnerabilities that come with it. Next, please. 75% of stateless people are from ethnic or racially minority backgrounds. At least 25 countries where mothers cannot pass their nationality or citizenship the same way their fathers can. Next, please. And so the ways it happens, and all of these kind of intersect with each other, and it's practically happens in every corner of the world. Conflicting nationality laws. Naturally, each country's law create gaps where people just don't fit in or are uncovered. And a good example of this is US citizens who have not met the 5-year residency requirement, having children abroad in countries that do not have jus soli, fall through the cracks of being able to pass their US nationality to their children at birth. Discriminatory laws, we've seen them in the Dominican Republic, targeting Dominicans of Haitian descent. We've seen laws in the 1980s passed in Myanmar targeting Rohingya. These are specific laws that are passed oftentimes with the regime changes. Wars, border disputes, state succession, the Soviet Union, Sudan, South Sudan, Ethiopia, Eritrea, and you're kind of seeing regarding Ethiopia and Eritrea, the beginnings of what is going on in Tigray. Migration and genocide, again, Rohingya, Myanmar, Holocaust, Armenian genocide, and also some migratory groups like tribes in West Sahara, Palestinians, the Roma and the Kurds are oftentimes excluded. Administrative obstacles have become more aware, we have become more aware of migrants at the southern border here in the US that are being removed by ICE after giving birth to their child without being given their child granted US birth certificate, which creates a lot of issues when that child is growing up in a foreign country, and of course, obstacles from actually retrieving that delayed birth certificate. It is also important to note that collecting data is incredibly difficult regarding stateless people because states do not want to recognize statelessness oftentimes within their borders, but stateless people are often completely invisible before the eyes of any government and are forgotten or neglected. Next slide, please. So we are not only undocumented within the country we live in, but we are undocumented to the entire world. Next, please. And this kind of, I know within the undocumented population here in the US, it intersects. We are unable to have higher education. First of all, it's employment. So no right to work legally, unable to have higher education, upper mobility is limited. In the US, luckily, children are able to attend schools without having to have status. But unlike many areas of the world, stateless children are barred from education because they're unable to register. Healthcare, mental, physical issues, and of course, COVID-19 has exacerbated stateless issues because of their exclusion from any relief and currently vaccinations. Institute on Statelessness and Inclusion, or ISI, at the very beginning of the pandemic, in reaction to stateless NGOs around the world, launched their COVID-19 Emergency Stateless Fund to support efforts to address and advocate for stateless inclusion. And of course, the UNHCR this past week has also released a press statement warning of the growing vaccine gap for stateless people worldwide. In the US, I think this is so important why we need to, exclude questions around status, even nationality when distributing relief. Family separation, we have members of our community that have been separated from their own families. We have members that have tried to even deport themselves to see their family, but are unable to do so. And of course, deportation and or repeated prolonged detention. We have members of our community of Palestinian background that have been under ICE supervision for 40 years, but seem to have been placed on removal proceeding with every occurrence that U.S. engaged in with the Middle East, starting from Desert Storm, 9/11, and most recently the Trump administration. And the last two characteristics really did differentiate a stateless person living undocumented in the US versus a foreign national living undocumented in the US. So we have no embassy to go to. We are unprotected and we have limited path to remain in the US. And many of us have exhausted all options for relief, unable to adjust status in the US, and of course, unable to leave, what I mentioned earlier. And, we have members of, again, we have members of our community that also try to deport themselves, but we're unable to do so because they lack travel documentation and because the country of origin did not claim them. Next slide, please. An estimate of 70 US court cases mentioned statelessness between 1980 and 2011. Next, please. There is zero stateless legal framework in the US, and the US has not adopted the stateless definition either. Next, please. There is no official data or effort from the US government to quantify statelessness. Next, please. Many stateless people remain invisible, unprotected, unidentifiable, and possibly and repeatedly detained. Next, please. We have a challenge. This has been the status quo. Because the US does not adhere to international human rights standards, the US does not address statelessness as a domestic issue in the US. Stateless people in return in the US continue to live in the shadows. And many of us did not know that we were stateless for decades. We cannot answer the question, what country are you a citizen of? Stateless people themselves do not know that they're stateless. And then of course, the public remains in the dark and unable to advocate for stateless people. Next, please. But we're here to talk about a solution. And this model is a replication of what powerful movements behind the civil rights, women's lib, and of course, gay rights movement have done. We want to see the US adhere to and ratify international human rights standards. We want the US to pass our bill, the Stateless Protection Act of 2021, and policies that address and prevent statelessness in the US. We believe nothing about us without us is for us. And United Stateless aims to raise awareness and educate and advocate. With CLINIC here today, we aim to close the stateless knowledge gap among the legal community in the US. The public, we want to empower them and mobilize to advocate for stateless people, ensure that everyone's right to a nationality is protected and upheld. From the very beginning, our United Stateless most important value has been an organization led by and centered around stateless voices and lived experiences. And collectively, USL, our leadership and our community, we have experienced ICE detentions. We have had experienced family separation, homelessness, legal misrepresentation, fear of prolonged detention, inability to secure legal documents allowing us to work, marry, drive a car, and the inability to claim basic human rights. And, we are very young, we are grassroots, but at a core, we are community organizers, and we're more than just a collection of sad stories. The movement is more than a job for us, this is our lives, and we believe that our statelessness impacts our well-being, our families, and our communities. Next, please. And I would like to share my story. I was born in the Soviet Ukraine to Armenian and Ukrainian parents in 1988. And I want to just highlight that in the Soviet Union, you inherited the ethnicity of your father, and that is listed in your birth certificate. And toward the end of the Soviet Union, there was a rise of nationalism, and with new regimes and policies in various Soviet republics, there was the othering of certain specific ethnic and religious groups. My parents were considered a mixed ethnic family. As a young family, we could not live together. My parents, my parents' marriage themselves became dangerous, not only for themselves, safety, but also for their two young children, including me. So in 1994, 1992, pardon me, or around that time, we were able to retrieve an invitation to Cuba. And fortunate to be able to stop in Canada, get off the plane and seek asylum. And I was 4 years old at the time. And out of fear of denial and deportation in Canada, my family and I came to the US without inspection when I was 8. And we settled in West Philadelphia and began our asylum claim. 5 years later, after a third asylum denial in the US and subsequently the BIA, we were given a federal removal to self-deport without a country designation, and discovered that we were stateless when the Ukrainian embassy could not issue us travel documents and did not recognize my first Soviet birth certificate. And I was 13 years old at the time. In transition to independence, Ukraine did not extend its new nationality laws to specific ethnic groups, and especially if people were not in the country at the time. Ukraine also has a history of using denationalization to target activists and government officials. When you take someone's nationality away, you take away their vote, protection and access to law. At that point, you're not even considered a foreign national. After our final decision, my parents were then placed on ICE supervision, which thankfully didn't begin, as oftentimes it does, with detention. And this included ankle monitors, curfew, phone tapping for 6 months. This humiliated my parents. At 18 years old, I was meant to have been placed under ICE supervision as well, but due to an error with my A number that did not match, I became undocumented, and I did not fully understand what my status was because I never heard of the word stateless before. I learned that I'm stateless, not just undocumented, when my then US boyfriend and I wanted to get married. Not having an ID, this was tough, so we ended up going to Maryland because Maryland state law does not require ballot identification to get married. And we discovered that we could not adjust my status through our approved I-130 because the way I entered the US required a reentry. And because I'm stateless, I'm unable to travel. And I also want to point out that under Soviet law, children under the age of 16 were not eligible for travel documentation or passports. You were literally a name scribbled on the back of your parents' passports. And even though I could resolve the re-entry issue, if I do step off the US, I'll be self-deporting and triggering a 10-year ban. At 24 years old, I discovered an incredible legal counsel, David Benyon from the Free Migration Project, after 8 different lawyers, that urged me and pushed me, and we applied for DACA together. And I got my first ID when I was 24 years old. At the beginning of this year, also, UNHCR completed, and we'll talk about this more later, a stateless advisor opinion, which confirmed that out of the 4 countries, I have some kind of links to Georgia, because that's where my father's from, Ukraine, Canada, and the US, that none of these nationality laws apply to me, and that I am, in fact, most likely stateless. I am 33 years old, a stateless person. I've been under removal proceedings for the last 20 years. I'm a DACA recipient. I'm married to a US citizen with no path to nationality. And I am just one stateless story. And I'm also incredibly privileged because I'm white and I do not have an accent. Often I'm assumed to be an ally or even an immigration attorney. I'm not exactly on what statistics tell us, what ICE targets. And I live in a sanctuary city of Philadelphia. And most importantly, I'm married to someone with status, which is often my gateway to access basic needs. Next slide, please. So our advocacy roles, part of our mission statement to advocate for change in US law. We want the US government to adopt federal laws that allow a path to lawful permanent resident and pathway to nationality or citizenship. But in short of legislative reform, we want to advocate for the administration to protect stateless people from detention, offer valid forms of ID. We want to push for travel documentation that can be done at an administrative level. We want to stop unnecessary detainment or restrictive reporting requirements, issue travel documentation, collect and assess data, and sign the international stateless treaties. Next, please. Screening for statelessness. So I'll take a couple of slides before I transfer over to colleague Jessica. Next, please. Are there stateless people in the US? Yes, and you have met one today for the first time if it is your first time. In January 2020, Center of Migration Studies, or CMS, released a report that estimates that up to 218,000 stateless people or live in the US or are at risk of statelessness. This report is a robust first attempt and to quantify statelessness in the US due to the limited data CMS was privy to. But with the new administration, our goal is to submit more FOIAs to learn and we also anticipate more funding from ISI's COVID-19 emergency stateless fund to learn how stateless people are impacted in New York. And as you see, New York and California, it doesn't really come as a surprise as the highest populations. What CMS did find is that stateless people reside in all 50 states, with the top 10 pictured here. Next, please. The report also identified that stateless people in the US come from over 30 countries and territories worldwide. This is staggering because statelessness in the US doesn't have a specific look, versus other countries, they have a specific ethnicity group that they belong to and identify with. I would like to kind of point out the Americas. I mentioned the Dominicans of Haitian ancestry, about 8 years ago. I think it's going to be the anniversary of this coming September. The Dominican Republic passed nationality laws stripping nationality from Dominicans of Haitian descent. We also know that children born in Venezuela without registration go to a third party or third country, become stateless. We also know that Venezuelan parents living in a state neighboring Venezuela without jus soli are also having children that are rendered stateless. Cuba is an interesting example where children born outside of Cuba to people considered by Cuban embassy as permanent immigrants. And of course, the Mexican Constitution allows for naturalized citizens to lose their nationality, even if it renders them stateless after a period of 5 years abroad. And Chile, we've seen children born of migrants, specifically oftentimes Bolivian and remote and northern regions of Chile. Next, please. This, again, more examples here. And I mentioned earlier, children of US citizens living abroad, unable to pass nationality if they haven't reached that 5-year residency requirements. And, this also adds a challenge to how to quantify statelessness in the US because it looks so different. Now I have a question for you. If you have met or represented a stateless person, please type it into the chat box. Jessica and I are curious about this. And if you happen to know what ethnicity or what region they come from. Next slide, please. Give a moment. I'm just reading some of these. Very interesting. Okay, just moving along. So how does stateless people appear in US immigration? I often get this question a lot. And first, I want to flag that because US has birthright citizenship, the US doesn't necessarily create statelessness, but sometimes it does. I mentioned earlier, migrants, deported with their newborns before being able to be given birth certificate creates statelessness or at-risk statelessness, which gets even worse the longer time it's unresolved. Historically, enslaved people in the US were considered stateless, and their descendants weren't even considered citizens until the mid-1800s. And during World War II, there were cases of US government denationalizing or citizen stripping US citizens of Japanese descent. And we've also seen denaturalization cases repeated under the Trump administration. Stateless people intersect with every displaced community in the US. Some of us have overstayed our visas, whether student or work, and discovered that our country of origin does not recognize us anymore. Similarly, some of us have, unbeknownst to us, have failed to register with our embassies and rendered denationalized. We've crossed borders and have been denied asylum, like my family and myself, while others have been successful in claiming asylum claim and or have been able to reside in the US with refugee status. But even more so, there's members of our community that have lost status protection, rendering themselves stateless. Oftentimes when children are coming to the US with refugee status or have successfully claimed asylum, are discovering that they are in fact never really citizens as oftentimes they thought they were. We've been stripped of our citizenship through no fault of our own. Stateless people can be undocumented, but it does not mean that all undocumented people are stateless. You can be undocumented in the United States and have citizenship elsewhere. And now with that, I'd like to pass it over to Jessica.
Thank you, Karina. So Before I start, I just want to mention that I was first exposed to statelessness in South Africa, where I was hired by a national law firm called Lawyers for Human Rights in partnership with UNHCR in 2011. And we launched a project to provide direct legal services, impact litigation, and advocacy for stateless people in South Africa, most of whom are from other countries throughout Africa. And our project was based in a walk-in refugee and migrant rights law clinic. So one of the first things that we did was set up a mechanism to train our intake team to screen people who are coming into our clinic for services for statelessness. We also did screenings in the community, in various churches and migrant shelters. And we asked sort of a short set of questions to identify and estimate the numbers of stateless people that we tailored with specific countries of origin in mind. And like Karina mentioned, we had an idea of specific countries that we were looking for and kind of specific profiles. And in the US, it's much harder to do that because of the great diversity of countries that people are coming from. So in June 2020, I helped create a process for United Stateless to start to screen people who are contacting them, thinking that they're stateless, and to try and conduct detailed interviews to determine if they're stateless or at risk, with the goal of referring them for pro bono legal services in their area of the United States. And we've also started to do a lot of trainings of other organizations that provide immigrant services across the US. And one common refrain we often hear is, we do not really see stateless people. So knowing what to look for when you're screening for stateless people is really important. And this is because stateless people may not realize that they're stateless or have a word to describe their problem, and so will not necessarily self-identify as being stateless. So before we begin, I would love to ask folks to please type in the chat what kind of setting you're working in, whether you're a solo practitioner, or maybe you work for a big law firm, or maybe you're in a nonprofit. Do you do immigration detention visitation, community law clinic, a law school, government, etc.? I see a couple law schools. That's really great. We're trying to focus on educating law schools as well. Thank you. I see more and more responses. So when should we screen for statelessness? Ideally, we should always be screening for nationality, and you should never assume that your client is a citizen of whatever country they're coming from, right? So if screening is not feasible, so in some settings, it might not be feasible to really do an in-depth screening of every single client that comes in, but we wanted to go through and flag at least some high risk factors here that if you see any of these present, then you know you should do further investigation and maybe a more detailed interview. So the first thing is enabling documents. If someone has never had an enabling document, that's a big red flag. And when we say enabling documents, we mean a birth certificate, an ID in countries that have a national ID system, and a passport. It can also be the case that someone possesses a travel document that lists them as a non-citizen, or it can even say stateless or unknown. This is the most likely way that statelessness will kind of manifest itself in your client's life, is through their inability to access enabling documents. And if someone has never had a birth certificate, an ID, or a passport, and has spent years outside of their country of birth and outside their parents' country of nationality, it can become impossible to prove citizenship, especially if the parents are no longer alive or if the parents themselves don't have proof of their own citizenship. Another big red flag is obviously if someone's unable to be deported or to return to their country of origin. And refusal to accept a person for deportation is a good indication that a country does not consider that person a citizen, or at the very least, their citizenship is in question. And that's because the right to return to one's country is one of the main rights that citizens have as opposed to non-citizens. Born in a country without jus sanguinis, so without birthright citizenship, to foreign parents, is another big risk factor, depending on the laws in question. Many countries do not have birthright citizenship like the US does. And so that means that if you're born there, you're dependent on one of your parents passing on citizenship to you. And if both of your parents are foreign, it's not always straightforward and guaranteed that you'll qualify for citizenship in your parents' country of origin. An example is a child born in country A, which does not grant birthright citizenship, to a mother from country B, who is unable to pass on her nationality due to gender discrimination in her country's nationality laws, and to a father who's unable to pass nationality because he's either stateless or absent, or he may be deceased himself, or perhaps the laws in his country do not allow him to pass citizenship if the child is born out of wedlock. So the point is there are just lots of loopholes that can come into play. Another risk category is people of mixed nationality parents, and Karina provided some examples of this. And this is just the more nationality laws that come into play. You might think people have more nationality options, but actually it can create gaps, and especially in countries that prohibit dual nationality. Membership of a high-risk group or groups known to have high risk of statelessness, and Karina mentioned minority ethnic groups such as the Rohingya. And a couple slides ago, we did share specific countries that are known to host ethnic groups that are excluded from citizenship. And we do have a screening tool that we can share that has a long list of countries of origin based on the Center for Migration Studies report in 2020 that looked at statelessness in the US. And so we've kind of broken that down into a couple pages for you that you can use to help screen based on country of origin and ethnic groups. Another is born in a border region. This is an issue because if children are born outside of a hospital or clinic, there's often suspicion of fraud if someone is born in an area that's close to the border. And we saw this a lot in South Africa on the border to Zimbabwe. There were high levels of cross-border movement every day. Lots of informal traders went back and forth every day. And it was common for children to be born at home or outside of a clinic. And these children really struggled to have their births registered. And as Karina mentioned, also, we're seeing reports of people giving birth on the US-Mexico border and being returned to Mexico without US birth certificates, and also in the northern border of Chile. Nomadic groups is another one, and this is for obvious reasons because they move around so much. They may not qualify for citizenship in any of the countries that they move in. They may have trouble proving habitual residence and meeting certain requirements. They may not have birth registration. And born in refugee camps, so many refugee camps are in countries that do not have birthright citizenship. So the citizenship would follow the parents, creating challenges if that birth was not registered or the parents are undocumented or deceased. And from the CMS report of the top 8 refugee hosting countries in 2018, which was Turkey, Pakistan, Uganda, Sudan, Germany, Iran, Lebanon, and Bangladesh, none of them currently granted citizenship automatically to children born to refugees in the country. Another category is people born to a foreign parent in a country that prohibits dual nationality. So we saw this in South Africa where people who were born in a country prohibiting dual nationality, they were assumed to kind of have the nationality of the foreign parent. And so when there were laws in place that when you reach 18, if you did not renounce the citizenship of your foreign parent, you would automatically lose your claim to citizenship in that birth country. And oftentimes people are not aware that this is even the case, and so obviously don't take action in order to prevent losing their nationality. Another red flag is obviously if someone has experienced passport or other national ID stripping. Taking away someone's national identity documents obviously can be an attempt by the state to strip citizenship. And another one that's not on here that I just want to mention, that we couldn't fit them all on here, but unaccompanied or orphaned minors and adoptees. These are also categories that you want to just do further investigation to check if they have citizenship, if the parents are around and able to help provide any kind of documents. That's obviously not the case if someone's orphaned or unaccompanied. And another category is adoptees. And we have seen some cases of people brought to the US as children through adoption who were never able to naturalize. And oftentimes it's obviously not the child's fault that they were not able to naturalize in the US, but then they became adults and realized that they weren't able to, they kind of got stuck. And sometimes with criminal convictions, they lost their LPR status and found themselves unable to leave the US. Next slide. Okay, so these are some intake screening questions that you can consider using that will flag some of these issues for you. And the first one is, have you ever had problems accessing a birth certificate, ID, or passport? You'll want to find out if the person has ever had an ID, birth certificate, or passport, because obviously if they lost it or it expired, then it's possible that they can have it reissued versus if they've never had one. Again, right of reentry. Have you ever been detained by immigration or ICE, but they couldn't find a country that would accept you? And the last one is sort of more of a catch-all, sort of a conversation starter. Have you had problems accessing citizenship? And you can try and probe more about benefits that only citizens would have access to depending on that country. So an obvious one is voting rights, right to travel, right to access loans, education, medical care, and as Karina said, during COVID times, access to vaccination. Next slide. Okay, so once someone presents a risk factor, you're going to want to do a more in-depth full interview. And where do you start? So the obvious place to start is family history. You want to look at the person's place of birth or date of birth, their parents' nationality, their parents, were they married at the time of the person's birth? Because if you're born in or out of wedlock, the laws might differ. Adoption, and then obviously, as I mentioned it before, are the parents still alive? Can the person access the parents' documents? And personal history. So marriage obviously might provide a path for some people to citizenship, and as well if someone had periods of long-term residence in a state. And then again, documentation, you want to focus on what kind of documentation levels they have. And also, have they ever made any attempts to get documents? If they have made attempts, why did they fail? What did the authorities say? Were there any decisions, administrative decisions that were issued to them in writing, denying whatever they were applying for? And you obviously want to look at their full immigration history, both overseas and in the US, to see what kinds of claims they might have overseas, as well as to see how their history has impacted their options to relief under US immigration law. And I want to just mention that we do have a sample intake form that we can share if people are interested, that provides like a really detailed interview, a template for an interview that would capture a lot of these questions. Okay, next slide. So after your interview, you want to start researching the nationality laws that apply to your client. And a quick refresher, obviously, on how nationality is acquired. It can be automatic or non-automatic, and it can be discretionary or non-discretionary. So your assessment and your action plan might differ depending on whether the law that relates to your client is automatic or discretionary in nature. And we recommend that you create a timeline or like a draft statement of the person's whole life, starting from birth until the present, to put everything into context and make sure that you haven't missed anything. So again, you can acquire nationality automatically at birth, by birth in the territory, or through descent. And descent can include the grandparents as well. And you can also acquire nationality by declaration. Sometimes, it will seem automatic in that you're a citizen if you're born on the territory, but there might be a caveat that will say, provided the birth is registered. And so until that birth is registered, that person's not considered a citizen. But when the birth is registered, it's not discretionary to grant citizenship in that case. And it's the same for countries that have a declaration of loyalty requirement. You have to take that action before you can be considered a citizen. And then upon application, so that would be, of course, through marriage, naturalization, long-term residence, and in some cases, birth on the territory combined with long-term residence. You can have options for citizenship in some countries. Next slide. Okay, so we're going to go through sort of the basics of applying the stateless definition. And so you suspect that your client's stateless, and now you're going to try and actually determine if they meet the legal definition of stateless. So for the next few slides, we're going to break down the definition of stateless piece by piece. And this is all based on the UNHCR handbook on the status of stateless persons, which is meant to accompany and explain how to apply this definition in line with the Convention on the Status of Stateless Persons. So the first question is by any state. So a person is stateless if they're not considered as a national by any state under the operation of its law. So first you look at the definition of a state, and the guidelines point to the 1933 Montevideo Convention as well as international law. And this is kind of an open question that you're going to want to look at international law, and you might want to find an expert, a subject matter area expert on this question, depending on where your client is from. There obviously can be room for disagreement and for argument on this point. Which states, so when you're looking at state, we're not looking at every state in the world. Luckily, we're not required to check every state in the world. We're just looking for states where the person has a relevant link. And relevant means they have a substantial connection to that country, either through being born on the territory, through blood, so one of their parents or grandparents is from that country, or through long-term residence or marriage or adoption. So not just a state that somebody passed through on the way to coming to the United States. Next slide. So the next part of this assessment is looking at not considered as a national under the operation of its laws. So there's two things happening here. One is law and the other is state practice. And so law here is meant to be interpreted broadly and to include not just legislation, but also ministerial decrees, regulations, orders, case law, customary state practice, and more. And it depends on each case in each country. There could be circulars, perhaps, that the Department of Home Affairs created to say this is how this legislation is meant to be interpreted, and that's included. So what you want to do first is obviously look at the citizenship law that was in place on the date of birth of your client. So this might require some digging because the law may have changed. You're also going to want to look at any relevant amendments to the law and to any regulations that have come into place in the interim, as well as any recent orders or decrees that might apply to your client or to people in the same ethnic group. So state practice, the handbook really highlights the fact that this is a mixed question. Statelessness is a mixed question of fact and law. So a state may not in practice follow the letter of the law, even going so far as to ignore its substance. So you want to listen to your client's story. Don't just look at the law, listen to what the client is telling you happened to them, and look at how people who are in their same kind of ethnic group or category are treated by that state. So sometimes you're going to have to dive a bit deeper. Okay, next slide, please. Okay, so not considered as a national. And when we're looking at whether someone's considered as a national or not, we want to identify the competent authorities in that state, which are the authorities responsible for conferring or withdrawing nationality or for clarifying nationality status. So a few points I just wanted to highlight, which were helpful from the handbook, which is that a low-level local government official can constitute a competent authority. It's not necessary that the highest level, that the person appeal the decision to the highest level. The decision can be valid just from a local level government official, depending on the case, of course. And then the other thing to highlight here is that this is a present tense assessment. And so we're looking at what is the person's present status. And if a non-automatic nationality mode is relevant, then steps must be taken before the person can be considered a citizen. In some cases, registration or through application. And if it's an automatic nationality mode, so the person, for all intents and purposes, should be considered a citizen, but they're not, or they're struggling, or status is in question, then you obviously want to find out why. Next slide. So more about the viewpoint of the state, and you're going to want to gather proof, whatever proof you can find. So administrative applications, any applications they've made for birth certificate, ID, passport, or obviously citizenship recognition, consular interviews or letters, detention interviews. Sometimes we've had interviews with people who've been in ICE detention who were interviewed by consulates, or who ICE came and brought them citizenship applications to fill out and file. You want to find out the whole story, anything like that that can provide proof. And then you want to look at access to services or rights limited to citizens. And like I mentioned before, if they've struggled to access, rights that would be limited to citizens. And I just highlighted this quote from the handbook that I thought was helpful, similar to what I said in the earlier slide, which is that if the competent authorities treat someone as a non-national, even though they appear to meet the criteria for automatic acquisition of citizenship, it's their position rather than the letter of the law that's determinative in concluding a state does not consider them as a national. And there might be multiple conflicting occurrences that you have to take into account. So somebody might have had different experiences with the authorities in their home country versus when they're in the US and approaching consulate officials. So it is also a balancing act to put all the proof together and to, weigh it up against each other. In the US, it's likely to be the consulate that you're going to go to find out how they feel about the person's citizenship status. Okay, next slide. So just a few pointers for looking at foreign law, things to look out for. Karina already mentioned gender-specific clauses or regulations. Obviously, there's things that can specifically say a woman can't pass nationality to her child, but it can be more complex than that. And it can include barriers to birth registration. And we actually had regulations in South Africa that precluded someone who had been born out of wedlock to an undocumented mother and a South African father from getting birth registration if the father was unable to acknowledge paternity. And so it can be more complicated than just reading the law. And so loss obviously can occur. You can lose your citizenship through denaturalization, through state secession, through amendments to the law, and obviously through the court process. And then loss can be automatic in some cases. So you might want to keep an eye out for any provisions that would apply to your client. Time spent abroad is a big one. People who are considered a security risk or who are convicted of certain crimes, or marriage to a non-citizen in some countries can result in you losing your nationality. And then deprivation of nationality can occur by order. For example, failure to perform a military service. Sometimes if it's argued to be in the public's interest to deprive someone of citizenship, or through suspected fraud in the naturalization process. And then I also just wanted to mention renunciation. So some countries will require that you renounce your citizenship before naturalizing. And if obviously your naturalization application in the new country is rejected, then you are in a situation of statelessness. And next slide. So some things to look out for in foreign practice. The handbook provides some helpful guidance that non-response from competent authorities after a reasonable period of time can be used as evidence with the full picture of the case, but can be used as evidence of lack of state recognition of citizenship. And this can be helpful because it can be years that go by where authorities do not respond to an inquiry, or their response is so superficial that it doesn't even apply the facts to the case. And so that's something that's helpful. And then you obviously want to consult country research for similarly situated people from this country or region. And you can look up the citizenship laws of other countries on Westlaw or Lexis. RefWorld is a really good source as well. The consulates often have citizenship law on their websites. And it may be the case, though, that you're going to have to rely on attorneys in the country of origin. You might need to reach out to someone who has access to laws or regulations that you can't access. And there's also citizenship law books that can be helpful. For example, Bronwyn Manby's Citizenship Law in Africa was really helpful when I was working on statelessness there. And then keep an eye out for discriminatory citizenship laws and practices. Again, a lot of this will be provided in RefWorld resources. And an example is in Zimbabwe, where Robert Mugabe's government changed the citizenship laws in the early 2000s to automatically withdraw citizenship from people born in Zimbabwe to a foreign parent. And this is widely viewed as having been done for political motives to disenfranchise people who were more likely to support the opposition party, which was the MDC. And I just want to finally flag that not all travel documents are made equal. So people may have come here on documents that, like I said earlier, actually state non-citizen or stateless. And if those documents expire, they don't always have the right to renew them for obvious reasons, because they're not a citizen. So we've seen multiple cases like this in the US. Next slide. So how can you help? I hope that this will help you consider screening for nationality more often. And some ways you can help: you can consult with a stateless client or someone who has maybe is at risk of statelessness. Help them understand their nationality status. So some of them, don't understand whether they're citizen or not, and really need someone with legal background to do the research for them. You can write to consulates, you can set up interviews, obviously if it's in the client's best interest and that's what they want. You can help them apply for citizenship claims if that is in their interest and there's no protection concerns. And we want to encourage you to encourage your clients to apply for citizenship in the US as soon as they're eligible, because we are seeing people who were asylees or were refugees or were LPRs who lose that status and are stateless and are unable to get any kind of status back. Detention: if you have a detention visitation program, please keep an eye out for stateless people. And they're usually the ones who have been in detention for the longest periods of time, and please help them get released. And then identity documents is another thing that can really make a difference and be a game changer for people who are stateless in the US. And it depends on the state and the city, but there's some states and cities that have more friendly requirements where stateless people can become eligible for local IDs. And if they are able to obtain them, sometimes it's the only valid legal identity document that they will have. If you come across people who are stateless or you think might be stateless, please connect them to United Stateless. This is the general email address and the website. Please advocate for stateless people. Please, when you're thinking about your own advocacy and your own agendas, think about how it might affect someone who's stateless. And if you have questions, please reach out to United Stateless. And obviously, please help your clients apply for immigration relief. And this is where I hand it over to Vicki.
Great. Thank you so much, Jess. So I'm going to talk pretty briefly about possible forms of relief, because we are going to be offering another webinar in the fall where we talk about what kind of relief might be available to people who are stateless. But we're going to just touch on some, possible issues regarding relief, so that as you're doing screenings and thinking about whether this person is potentially stateless or not, at the same time, you can be thinking, well, what relief might be available for them. So as Karina said before, even though there are, dozens of cases in the United States that touch upon statelessness, there's no path to any kind of legalization based solely on being stateless. So we're talking a lot about figuring out, is that my potential client stateless? But even if the answer you get to is yes, or probably, that doesn't mean, oh, good, that means that this person is now eligible for relief. However, in many different forms of immigration relief in the United States, all of the issues that we've been talking about today, whether or not a person can get documentation of their birth and their identity, how they entered, whether or not they're allowed to re-enter, can all affect somebody's ability to apply for relief in the United States. So, I think one of the most common issues that I think of when I think of statelessness is, well, does that make somebody potentially eligible for asylum? And if you, look back to the list of countries and ethnic groups where statelessness is common, unsurprisingly, those are generally countries where there's been some sort of, civil unrest or discrimination against groups of people. And those issues often overlap with issues of persecution, which can form the basis of asylum. That being said, there are numerous cases in US federal courts that say, statelessness per se does not equal persecution, right? So to win asylum in the United States, you have to show that you have a well-founded fear of persecution based on race, religion, nationality, membership in a particular social group or political opinion. But simply the fact that a person is stateless, that they don't have those protections from some other country in and of itself does not mean that a person meets the definition for persecution. The conditions that a stateless person may have been subjected to in their country where they were residing may end up rising to the level of persecution, but it's always going to be a case-by-case analysis. There is one line of cases, couple of cases that say that denationalization, so if a country decides, as Jess was just talking about in Zimbabwe, where you might have a leader who says, okay, everybody from this background, we are stripping you of your citizenship. Some cases say if the reason for that denationalization was linked to a protected characteristic, such as a person's race or their religion or their ethnicity, then maybe that is persecution per se. So, for example, in one Seventh Circuit case, the judge basically asked the government of the United States, who was defending a lack of a denial of an asylum grant, well, are you saying that in Nazi Germany, the fact that the Nazis denationalized Jewish people would not have been persecution per se? And the government said, basically, no, it would not have been. And the judge in that case disagreed, fortunately. But it's something just to be aware of. On the other hand, if there are sort of facially neutral laws that just say, okay, if you were born in this territory after X date, you no longer require citizenship. If there's not some link to that protected characteristic under asylum law, then that in and of itself would not be sort of per se persecution. And again, you'd have to look to the actual conditions that the person was living under to see if that rises to the level of persecution. So lots to think about there, and something that we'll delve into much more in our second webinar in this series, but be aware these issues are definitely raised, but being stateless doesn't mean in and of itself that a person qualifies for asylum. Another thing to think about is cancellation of removal. So for many stateless people have been in the United States for a very long time. If somebody's been in the United States for at least 10 years and they can prove that their removal from the United States would result in exceptional and extremely unusual hardship to a US citizen or lawful permanent resident, spouse, parent, or child, they may be able to get lawful permanent resident status. This is only a form of relief that's available to people who are in immigration courts, so they have to be in removal proceedings. And that legal standard of exceptional and extremely unusual hardship to a qualifying relative is intentionally very high. And that hardship has to be to the US citizen or lawful permanent resident. So almost by definition, the statelessness hardship that the applicant who's in removal proceedings would suffer doesn't translate directly, because the hardship that the non-citizen in proceedings is suffering from isn't part of the legal analysis. But if, for example, you have a person who is stateless, and if they are ordered removed, their US citizen spouse would go back to their country of last habitual residence, where maybe they wouldn't have many rights, they wouldn't be able to work there, they wouldn't be able to pursue education. That might be something where you could show that you meet that level of hardship for the qualifying relative. There are other humanitarian pathways to lawful permanent residence in the United States. U visas for crime victims, Violence Against Women Act protection for people who are in relationships involving domestic violence, T visas for people who have faced human trafficking, special immigrant juvenile status for people who are in the United States and only have one parent or no parent who can care for them, or family-based immigration. And we heard from Karina's story. I think a lot of people think, well, if people who marry a US citizen, that sort of almost automatically gets you to lawful permanent resident status. But for people who entered without inspection, they can't get lawful permanent residence from within the United States. And if you then can't travel outside the United States because there's no way to get a travel document, then there's not a way to get lawful permanent residence based solely on the relationship. That's one reason that some of these more humanitarian forms of relief, like asylum or cancellation of removal or a U visa, can be very powerful, because for those forms of relief, a person does not need to have entered the United States lawfully, but sort of by intention, those humanitarian forms of relief can be quite difficult to win, and they each have their own very specific level of proof that the person needs to show. So what about temporary forms of relief if there's not a permanent pathway for a stateless person? So temporary protected status is a status that the United States can give to people, sort of as a blanket form of relief for people from a particular country or from a particular region within a country. It's generally granted because of either some sort of natural disaster like a hurricane, or some sort of civil unrest like a civil war. And this is one of the places in the Immigration and Nationality Act that actually does recognize that statelessness exists, in that both for temporary protected status and for asylum, there is language that says, and for individuals having no nationality who last habitually resided in ... So there is at least that teeny bit of recognition. There's really not, there's no definition of what last habitually resided means, and cases have interpreted that in different ways. So even sort of figuring out where a client last habitually resided can be also a bit of a tricky inquiry to look into. For some courts have found that it's, if you've been somewhere, that it's really a quantitative analysis. How long was the person there, or was it the place they were in most recently before entering the US? Other courts have looked at it more qualitatively, looking to what the person's intent was, whether they intended to stay in that other country permanently or not. But, temporary protected status. So, I mean, it's important to think about, even if the person is not a citizen of one of the countries that's currently eligible for temporary protected status, if that's where, if the stateless person last habitually resided there, that could be at least a pathway to get some temporary relief, to get the ability to stay in the United States in authorized status and get work authorization. So deferred action is another possibility. So I think many of us are familiar with deferred action for childhood arrivals, which is sort of a subset of deferred action. Or maybe, I'm not very good at math. I don't know if a subset can be bigger than the set as a whole, but the idea behind deferred action for childhood arrivals is that if people meet certain criteria, they're allowed to stay in the United States without fear of being removed, and that they can have work authorization. Before DACA existed, both Immigration and Customs Enforcement and USCIS have had the ability to grant deferred action, which just means basically the government knows that the person is here, the person doesn't have any actual full lawful status, but US government is not going to take steps to remove them from the United States. And people who qualify for deferred action can generally get work authorization along with that. Whether or not to apply for deferred action is a complicated question. Right now, we seem to be in an administration that is going to be more open to that sort of relief. But of course, for someone who's sort of not on the radar of Department of Homeland Security, even if they get deferred action now, I think what we've seen under the prior administration is just how quickly immigration laws and enforcement priorities can change. So there's always sort of a fear of putting someone on the radar, even if it makes things better for them in the short term, that there could be long-term repercussions. Orders of supervision, stateless people often end up detained for long periods of time because the US government, particularly if they have a removal order and the US government is seeking to remove them and can't find a country to which they can remove them. In that situation, the stateless person can be released under an order of supervision by ICE, which may mean that they have to check in and report. The positive part of an order of supervision is that people under orders of supervision can apply for employment authorization documents based on being subject to OSUP. Under the Trump administration, there were actually proposed regulations that would have removed the ability for people under orders of supervision to apply for employment authorization documents, but fortunately, under the new administration, they have rescinded that proposed regulation and clarified in that rescission that DHS believes that it is the appropriate path to continue to offer employment authorization documents to people who are under orders of supervision. As I said, one of the things that we've seen already with the Biden administration is we seem to be returning to a culture similar to what we saw under the Obama administration, where rather than saying any non-citizen in the United States who is not here with legal status is an enforcement priority, that they intend to use resources in a way that focuses on people who are considered a security threat or a danger in some way, rather than people who have been in the United States and don't pose those sorts of threats. So some of the factors that OPLA, the Office of the Principal Legal Advisor, or the ICE attorneys who appear in immigration court can look into in exercising prosecutorial discretion. So this could be for people who are in removal proceedings. If there are, quote, compelling humanitarian factors, if there's a long period of residence in the United States, those can be reasons that ICE would move to dismiss removal proceedings against someone. not to pursue an appeal if the person wins some form of relief, agree to stays of removal, and join or not oppose motions to reopen. So it's something to think about. Again, there are many stateless people in the United States who have old removal orders, either because maybe conditions were not as bad in their country of last habitual residence when they applied for asylum before. Maybe they had counsel who just didn't even understand what it meant to be stateless, or that the client was stateless. So this might be a moment in time to think about connecting with a lawyer again to look into whether or not this is the moment to do a motion to reopen, in that it does look like DHS is going to be a little bit more generous in agreeing to motions to reopen than they have been over the last few years. Another resource to keep in mind if you are working with stateless people is UNHCR. As I mentioned at the beginning of this webinar, they have sort of put together this partnership between USL and CLINIC. And one of the resources that they can offer is actually writing a stateless advisory opinion. And having that opinion, I mean, just talked at length about sort of all the steps that an attorney or representative may go through to try to determine whether their client actually is stateless. UNHCR can do that for you, and they have better resources to make that determination. And if you have an SAO from UNHCR, that carries a lot of weight in convincing the United States that your client is stateless, and that's a determination that you can use to help advocate for prosecutorial discretion, or potentially can be helpful in a claim for asylum or another claim for permanent relief. So what can we do? We're talking about this partnership between our organizations. CLINIC will be working with USL to provide mentorship on some cases and create practice materials for other attorneys and representatives. And Karina and Jess, why should people who are working with stateless clients or potentially stateless clients contact USL?
So obviously for community, if you have questions on screening, on identifying stateless people, we do screenings, but we are we are volunteer based, and we have limited resources. So we want to train you to also become experts at screening and interviewing stateless people. And we're happy to provide trainings to you and your staff on how to do this and talk through different kinds of case scenarios. But we do take cases that come to us, we do interviews, and we try and place those people with attorneys. We do not provide direct legal services ourselves, but we try to connect people with attorneys in the area. And if you're interested in taking a case pro bono, obviously please reach out to us. And with the CLINIC mentorship, there's support. You have support to take these cases on. You have CLINIC, you have us, you have UNHCR.
Great, thank you. There are several resources, and some of these we've talked about already. UNHCR has a couple of really great resources that you can find by Googling, or maybe I should see if I can put this. Oops. No. All right. Well, we can provide this if you want. US Stateless put together this Google Doc that just basically links to some of these resources that are here. But UNHCR has both a handbook on stateless persons and a legal guide to representing stateless people under US immigration law, which is really a great starting point to understand some of the issues that are raised in these cases. Just also referred before to the CMS report on statelessness in the United States, which gives a really great overview of who may be stateless here. And then, as we've mentioned a couple of times, if anybody would like to join our statelessness listserv that will be a place where people can share questions, make referrals, share resources, and you can join that just by emailing me, bnielsen@cliniclegal.org. So we still have about 10 minutes. I don't know, Karina and Jess, if you've had a chance to look at some of the questions in the Q&A, and if we have time to answer a couple of those, that would be great.
Jessica, I feel like you can answer these questions so easily. Should we start with the first one from Olga? I had a passport before, but now I cannot get a birth certificate. What can I do? I guess my non-lawyer background is contact the country of origin to see if they have records of you. Is that correct?
So, yeah, and I think it would depend where you're born, but so if you have a passport but no birth certificate, so this is the case, a lot of countries don't have strong birth registration, and I don't know the exact statistics, but there's still a significant percentage of human beings on the planet whose birth has never been registered. Birth registration is definitely not universal yet. And so there are a lot of countries will have a process for late registration of birth or for delayed registration of birth, or they may have other words for it, but basically that's what you want to do is apply for late registration of birth. And each country will have its own requirements on how to access that.
Great. I see a lot of questions about how to do the research or where to go for that research. And I think that you addressed a lot of that before. There's a question about de facto statelessness or statelessness that's created by a person who cannot establish their nationality because they don't have sufficient documentary evidence. Is that something that you see a lot at USL? So
this concept of de facto statelessness has kind of fallen away a bit in the field because it's not a very useful term. The definition that we just went through and the guidelines issued by UNHCR on how to interpret the stateless definition encompasses a really broad guidelines that you can use. So if someone has insufficient documentary evidence to a certain extent, that will rise to the level of them being stateless under this definition. So de facto statelessness is not really relevant in assessing whether someone's stateless or not, because the term is not part of the definition. But it is a term that's kind of floated around in the community, and it has caused some confusion, but it's sort of encouraged to just focus on the definition and the guidance when you're interpreting the definition.
And I think a somewhat similar question, a person who is in the USA with refugee status, is that person considered stateless even though they have a passport? I mean, I think the answer to that is it depends. Not all refugees are stateless. It would depend whether they, I think what Jessica was talking about was some people who are born in a refugee camp in a country that doesn't have birthright citizenship, maybe stateless. But I think this is sort of, to me, going a little bit to the same question of like, what's the relationship between the documents that you have and whether you are stateless as a legal matter. And can you talk about that at all, Jeff?
Yeah, and I also was thinking they might be referring to someone who is here on refugee status but has a refugee travel document. So they could still be stateless unless they have a US passport, right? So if the passport is a US passport they obtained because they got refugee status and then naturalized in the US, then they're no longer stateless. But if they're a refugee with a US travel document, they're not a citizen. If they're stateless and a refugee, they need to naturalize in the US in order to get US citizenship.
And And is there anything, can you say anything, Jessica or Karina, about the difficulties that people have trying to prove family relationships if they don't have birth certificates, or if they're, you know, born in refugee camps or border regions where it's just really difficult to get documentation? And do you know whether that's something that UNHCR can help with in terms of just proving the family relationship?
So this is a challenge. Again, it's kind of, it depends where the person's coming from. So we've been surprised sometimes UNHCR actually was able to help in one or two cases provide documentation that a person was in a specific refugee camp and track proof of that. But I guess it's going to depend on each case, and I can't speak for UNHCR and what they're able to do on this. But it is hard to kind of backtrack and prove someone's citizenship claims once they're in the US. And if they're here alone, that can be a big challenge. But it's kind of being an investigator and helping gather any kind of evidence at all that can help the person's case. So for example, I wrote to a client's elementary school in Kenya asking for proof that he attended. I wrote to the high school that he attended in Uganda asking for proof that he attended. This was a person who was an orphan. We tried to find death certificates. We applied for birth certificates. It's just each case is different, and trying to help gather the breadcrumbs that can help prove someone's existence.
Thanks. So we have about 2 minutes left, and a lot of the questions I think are going a little bit more toward relief, which we definitely will be covering in the next webinar. But I was hoping, Karina, that maybe we could end. You mentioned before the Stateless Protection Act of 2021. Could you just tell us a little bit about what that would, what protections that would bring to people if that were to become law?
Yeah. So I'm going to start by saying that there was every version of the Refugee Protection Act from the beginning had a stateless section in it. What we did, we being some of our stateless members and legal experts and policy people, sat in a Zoom room together and went through the act and pulled the language out and expanded to reflect lived experiences, but also to reflect the CMS report and what we're seeing in our intake. The law establishes stateless definition. So I'm really grateful Jessica went through the stateless definition, because if we're so lucky, knock on wood, we'll need a lot of lawyers to be able to understand the stateless definition. It establishes a stateless status determination, similar to what UNHCR is doing in this case, a stateless advisory opinion, but we're hoping it will be done by the USCIS. I think that's where it falls into, to look at all available evidence regarding a stateless person to determine if that person is stateless or not, all based on the UNHCR handbook that Jessica mentioned. And our goal then is immediately be able to be considered LPR, and also to release stateless people in detention, and pathways to citizenship. And Jessica, you can go on this a little bit more, but we also put a clause in our act about inadmissibilities, especially around crime. And what we're asking for is a protective status to be able to allow folks, maybe they won't be able to have citizenship, but they have some kind of protective status in the US. What we want to prevent is, a lot of these questions are addressing, is that, yeah, it's hard to prove that you're a person born where you are. That's the biggest issue a stateless person has. Just using myself as an example, at one point, the only ID I ever had was my high school ID, my Soviet birth certificate, and a translation. That's all I had to prove that I am. I mean, if I had a house fire, like, where do you go to find documentation when, my country dissolved? But our goal is to allow leniency around statelessness and use that as a humanitarian protection. The Department of State is very much pro resolving this issue around the world, and our act also strengthens their role.
Great, thank you so much. And I think with that, we are at the end of our time. So I want to thank everybody for coming and for the great questions. And if you have a question that is that we didn't get to that you need an answer to before our next webinar in the fall, you can reach out, I think, to any one of us. Yeah, please join the listserv and look out for our next, for our next webinar. Thanks so much, everybody. Thanks, Jess. Thanks, Karina.